Hello, this is Brian Ka with another video to help you pass the baby bar exam. So I want to start this video with my recent experience in looking over some Yelp reviews because when I have some time during the day, I like to just browse through different cities. I like to type attorneys in the search box on Yelp. And I like to just look over what clients have to say about their recent experience or their past experiences with their attorneys. The reason why I am bringing this up is because I have seen so many bad reviews. I mean, I'm not going to mention exactly what city I searched in, but in more than several cities that I looked at, there were attorneys that really had horrible reviews. I mean, there were reviews that said my attorney took me to court and refused to fight for their client because they were afraid of the opposing counsel. And not only that, there were just so many instances of clients' complaints saying that their attorney never called back. It was virtually impossible to talk to their attorneys. Several cases, I saw some fraud cases, and even some of these clients even took their cases to the state bars. So you can imagine how pissed off they were. And we know that this legal field has a pretty, I wouldn't say a great name or reputation. And I can understand why, because there are many greedy attorneys out there who are not there to help their clients, but rather they're after money. So when you're after money and not focusing on resolving problems for their clients, that's bound to create more problems down the road. So the reason why I am mentioning this in this video or starting out this video with this story is because many times as students like myself who had to take the baby bar and who didn't go through you know Ivy League law schools like Harvard or Yale or Stanford, as a matter of fact. A lot of people, even on YouTube, say that which law school you go actually matters, and I agree. When it comes to getting big law firm jobs, of course they'll look at whether or not you went to an ABA school or like a top tier, top 10, top 20 law school in the nation. And that's totally understandable. However, as I said, looking over so many bad reviews of so many attorneys who are working currently in different parts of California, I want to tell you that the first thing that came to my mind was that there are so many opportunities for good lawyers, good attorneys who are going to serve their clients' needs and really, really get after their legal problems rather than doing it for the money. And there is a person or a YouTube channel that I am subscribed to. And I really enjoy watching, and that is Trial Guides LLC. And I mean, he always invites trial lawyers who have been very successful and just talks about different tips that you can use during trials to make you a better trial lawyer. But the main thing about him is like at the end of each video, he mentions that as attorneys, let's try to lessen the suffering in this world and really try to make this world a better place. And that's what really hit the bell for me because obviously more than 90% of students are going to be in it for money. And I understand that. And if you're successful as an attorney, it can be quite lucrative. And I understand that too. But I believe, in my opinion, in real lawyering or becoming a real good attorney is to really advocate for your clients or their needs or really resolve their legal issues or problems. So as long as people like us who was not, I guess you can say, I don't want to say not smart enough because people are gifted in various ways. Some people may be better at creation and art and music, and then later on decided to try law school and finish law school. Whereas some students are just book smart and their parents are attorneys, and since you are 3 years old, they taught you that all you have to do is memorize the black letter law. And you know how they say that your brain is in a theta state from when you're born till you're 7, and whatever you learn during those 7 years basically carries you forward for the rest of your life. And I kind of believe that. But at the same time, they say that another way to train your theta brain is through repetition. And as long as you repeat and keep repeating things in your mind and in your mental picture, and you just keep repeating again and again, then that's a sure way to get to where you're trying to go. So I think that it's important to know that, first of all, there are many opportunities out there, even though we may not be from, top tier law schools. There are still people, you can check it for yourself. There are still people out there who are complaining about their horrible experiences with their attorneys. And of course, there are lots of great reviews on certain attorneys too. But I'm saying that we can always, after we finish school and passing the bar exam, we can go out there in the world and try to lessen people's suffering. And money will follow if you can go out there and really try to help people and get rid of their legal problems. And if you do this repeatedly and you just keep practicing again and then again, just like how I am doing with these questions, you're gonna eventually get there. So have faith and always try to be positive, but always remember that in order for your subconscious to fully realize your full potential, only way to do it is by repeating through repetition, sort of like practice, the same things over and over until you get so good at your craft that you can start to talk about it and help people, or in my case, try to, teach fellow students who may be struggling with this test, which I also struggled with. So I think that is very important. And another thing that I wanted to mention in this video is that I was looking through some bar prep options. I was looking through Studicata, which is, he seems like a great guy. I looked at Kaplan and I thought that Kaplan may be good for me because they're going to be writing the test. So there's so much advantage, just by enrolling in Kaplan or Barbary. But they're like $3,000, like $3,500. There are other fees involved. I'm not 100% sure. So right now, I'm not able to pay that. I don't have that kind of money. I'm still a student, and I don't have that money. So I found this great site. It's called Bart Prep Hero, and they had a sale, Black Friday sale, in which they sold a $299 program for just 239, I think. And I purchased it. And what they give you is they give you all the licensed MBE questions, and I think there are about 1,200 licensed, officially licensed questions, and they wrote about 600 questions themselves. So I think it's close to like 2,000 MBE questions. Now, if you're looking for a bar prep that is going to teach you everything from each subject, black letter law, how to write the tests, then maybe this is not the one right bar prep for you. But in my case, I've been looking at past bar exam questions, and I've been just practicing on them every day. So I don't see myself struggling with the essay portion, but I know that for MBEs, the only way to get good at them is to just keep practicing. Even if you know all the black letter law and the exceptions to the rules, the way they test it, you just have to kind of get a feel for it. And I learned this because of my experience taking the baby bar, and that's why I say sometimes it was a blessing in disguise because the passing rate now is what, like 33% overall. Some schools, it's like 70%, and 60%. Some schools are like even 15%. But the thing I realized about the bar exam is that if you're a first time test taker and if you pass, then that's no problem. But if you fail it the first time, the percentage of you passing the second time and third time gets lower and lower and lower. Now, I know people who has taken the bar, you know, like 6, 7 times, and they finally passed after like eighth time, and that's great. But percentage wise, strictly just looking at the math portion of it, if you fail it the first time, the chances of you passing it gets slimmer and slimmer. So it's vital that you try to, in my opinion, try to pass the bar exam the first time. And in order for me to pass the bar exam, I realized that I need to start doing MBE questions now. And the thing is, for AdaptiBar, which is what everybody uses, they give you 4 months, 4 months like prior to the exam, and you can't, try it out before that. I mean, I think they have a program where you can just try a couple questions, but you can't really use their program until like 3 months before or 4 months before. And I need it now. I'm doing my second year. I am at the end of finishing a community property and child advocacy. And for the next trimester, we're going to start doing real property. So I needed to do real property MBE questions now because I am a slow learner. And when you're over 40, you kind of know yourself. You know what your strengths are, and you know what your weaknesses are. And one of my weaknesses is that I am a slow learner. And even though I'm a slow learner, if I learn something, I don't forget it. That's my strength, I guess. So I needed a program, MBE type of bar prep that'll get me, access now so that when I'm taking real property, I can just do MBE questions every day because that's a MBE subject. And what Bar Prep Hero does is that it gives you lifetime access. So that's another plus, another reason why I invested, $250 almost. And another thing is that they have a pass guarantee. And what that is as long as you went through like every question, went through their simulated MBE exam, and basically have done everything, and if you still didn't pass the bar exam, they refund you the money. So that's a pretty cool deal for $250. Even BarMax, which I used to pass the baby bar exam, they did the same thing. For baby bar exam, I had access 10 years later because I took the baby bar exam 10 years ago. And when I checked it, like when I was about to give another try on my second attempt, my BarMax account was still alive. So that was great. And I passed the baby bar exam using BarMax, but I think for their regular bar exam, which is around $2,000, I believe it's 1,995. I think that I'm not sure if they do lifetime access, or I'm not sure if they give you access to MBE questions, prior to, you know, 4 months before, or before that. So it was obvious in choosing Bar Prep Hero, and which was the best choice for me. So now I have it, and I've been doing MBE questions every day on Bar Max Bar Prep Hero, and I think it's been helping me. Reading comprehension, I am reading more slowly now, trying to understand every sentence. So I suggest that if you're going to eventually take the bar exam and you feel confident about essay portion, like me, I feel confident that I'll pass the essay portion, but I don't feel too good about, the MBE section. Then, this may be the right tool for you, especially taking account of the fact that it's only $250, And as I've mentioned before, Barbary and other bar prep courses are almost 4,000. So it's a great value. And as soon as I started, experiencing Bar Prep Hero and realized that it's a good program, applied to their affiliate program and I got accepted. So if you look at my description, you'll see a link to my affiliate link. And if you want to try Bar Prep Hero, just take a look at it and see if it's the right one for you. Then I suggest that you click that link and check it out. And it doesn't hurt to check out different options and what other bar prep companies do. So I really highly suggest that you check it out. And even if you're not taking the bar exam for another 2 3 years like me, I think that if you can do these MBE questions while you're going through these classes like real property, which I'll be taking in the next trimester, it's gonna obviously help you understand the concepts better. And like I said in the beginning of this video, repetition is all there is when it comes to learning, especially law school. So, I suggest that you keep repeating and practicing with these questions and, you know, do so many of them that eventually you just look at a question and without seeing the answer choices, you know what the answer is already. So, with that, we're gonna start with question number 54. Some motorists saw Strange, apparently disabled by illness or injury, lying on the sidewalk late at night. Motorists drove to a service station across the street to use the payphone. Tell was using the phone and refused to hang up when motorists explained the circumstances. There was no other phone in the vicinity. Motorist then drew a loaded revolver and threatened to shoot Tell unless he hung up. Tell then hung up and permitted Motorist to use the phone. Motorist is now being prosecuted for assault with a deadly weapon. Did Motorist have a privilege to threaten Tell with a revolver? Well, as soon as you read this question, I mean, you see somebody disabled on the street and you're trying to help the person, right? So you go to a gas station nearby and you see somebody using a phone because back then, because these questions were written in 1980. So, I mean, back then we had cell phones, but not as prevalent as now. So this motorist went to the person using the phone and said, if you don't, give me the phone, I'm going to basically shoot you. And they're asking you, is that permitted? Right? Well, for defense of others, it's whatever is reasonable under the circumstances. Now, the first thought that occurred to me when I read this is when you threaten to shoot somebody, is that reasonable under the circumstances? And this is just one of those questions where, in this particular fact pattern, I'm sure in real life, it may change because every fact pattern is different. But in this particular fact pattern, what they're saying is that this was reasonable under the circumstances. When a person was ill or injured on the street and another person was trying to help that person and goes to a nearby gas station to use the phone and another person was using that phone, I guess you can draw your revolver and threaten to shoot unless he hangs up the phone. And I guess for this particular question, they're saying that this was reasonable under the circumstances. Again, I don't really agree. When you threaten somebody with a revolver, that's a pretty scary thing to experience. But for the sake of this question, what my thoughts are, my opinion, it doesn't matter. What matters is what these test takers are thinking and their method of testing, right? So when you look at answer choice A, yes, because motorist was privileged to use deadly force if necessary to save stranger's life. That's a little bit extreme, so you can cross that out. B says yes because motorist was privileged to threaten the use of deadly force if reasonably necessary to save stranger's life. Again, I think the key word here is reasonable under the circumstances. And what they're saying is privileged to use deadly force if reasonably necessary, which is the same thing. So B is the right answer. C says no unless there was a statute specifically granting, granting such privilege. To me, that sounds, you know, if you get emotional for this fact pattern without being really a person who is a objective test taker, thinking like the, you know, test writers, then C would totally make sense. But as I said, in defense of others, what they're looking for is whether the actions of the person here was reasonable under the circumstances. And again, what they're saying is yes, it was reasonable under the circumstances. D says no if motorists did not know strange, and that really doesn't matter. So B is the right answer. So let's look at 55. Barney owned a hardware store in New York. Wishing to move to a warmer climate, he entered into a written contract to buy Samson's hardware store in Florida. The contract stated that Barney would buy Samson's store for $125,000, provided Barney finds a purchaser who will buy his present business for $100,000 cash. Samson rents the building in which his store is located under a lease with one more year to run. Okay, so a guy owns a hardware store in New York. He's trying to move to Florida, and he enters into a written contract to buy a hardware store in Florida. And in that contract, they said that the buyer would buy for $125,000, provided Barney finds a purchaser who will buy his present business for $100,000 cash. So right away, you know that this is sort of a condition precedent question, because what is happening here is this contract is stating that Barney will go ahead with the purchase as long as a condition is met. And what is the condition here? The condition is that provided that he finds a purchaser who will buy his present business for $100,000 cash. So knowing that, let's look at the call of the question. 55 says, assume Samson repudiated the contract soon after signing it and before Barney had made any effort to find a buyer for his present business. Barney sued Samson for breach of contract, and Samson defended on the ground that his promise to sell was unsupported by consideration. Will this defense succeed? Okay, so Samson, the seller, repudiated, right, in this question after signing it and before Barney had made any effort to find a buyer, right? So Barney sues Samson for breach of contract. What's Samson's defense? His defense was that his promise was unsupported by consideration. Will this defense succeed? Well, no, right? Because the court here will interpret the condition of Barney's promise as requiring Barney to make a good faith effort to find a buyer for his present business, because they're in a contract and there was a condition, but each had a duty to give their best effort to make sure this contract follows through. But if there was not even a good faith effort in trying to find a buyer for to buy Barney's present business, which is a condition precedent here, then this defense that there is no consideration will fail. So C is the right answer because, again, I told you that this question has to do with condition precedent. And even though if condition hasn't, if it wasn't met, then Barney would not have to go through the contract. But Barney still has to give his best effort in trying to meet that condition, right? He can't just say, he can't just be like, okay, I had a chance to satisfy that condition, but, you know, I decided not to just because I felt like it. That's bad faith because every contract is held to a, good faith and, high standard, duty of good faith. So C would be the correct answer. Let's look at A. Yes, because Barney's promise to buy was subject to a condition within Barney's complete control and was therefore illusory. Well, we know about illusory contracts. That's a contract in which a party says, okay, we have the right to basically get out of this contract anytime we want. That would be illusory. And here, there was a condition precedent, but when it comes to illusory, there was no illusory contract here. So that is not the right answer. B says yes, because Barney's promise to buy was still executory. Uh, Barney's promise to buy was still executory. It doesn't really answer the question here, right? Because we're talking about a condition precedent and whether there was good faith in trying to make sure that that condition was satisfied. So B is not the answer. D is no, because Barney's promise to sell his present business was consideration for Samson's promise to sell his business to Barney. Well, that's not the right answer because Barney's promise to sell his present business was consideration for Samson's promise to sell his business to Barney. It doesn't really address the fact that there was a condition precedent here. And the question is asking, will this defense of saying, there was not enough consideration, will this defense succeed? And again, this defense will not succeed because Barney had to give his good faith or best effort in trying to satisfy this condition precedent. So C would be the right answer. Let's look at 56. Assume Barney made no effort to find a buyer for his present business and refused to perform his promise to buy Samson's business. Samson sued Barney, and the evidence shows that Barney could have found a purchaser to buy his business for $10,000 cash. What result? Right? Well, again, if a party who had a condition on his contract, and if he fails to meet that condition, then performance wouldn't occur. But that effort in trying to meet that condition has to be done in good faith. And here they're saying assume that that Barney didn't make any effort or no effort to find a buyer for his present business and refused to perform his promise to Samson's business. That's already telling you that there is something about bad faith here, right? And because of that, Samson sued Barney, and the evidence shows that Barney could have found a purchaser to buy his business for $10,000 cash. So obviously, that's bad faith, failing to find a buyer, even though he had a chance. So obviously, the answer is going to go towards Samson winning. So we can automatically cross out C and D because Barney is not going to win because he didn't give his best effort. Now, when you look at A, it says Samson wins because the condition of Barney's promise was excused by Barney's failure to try to make it occur. Right. That sounds like a good answer. Samson wins. B, because the stipulation about the sale of Barney's present business was a mere promise and not a condition. And that is totally wrong, right? Because stipulation about the sale of Barney's present business was a condition. It was not a mere promise. So we can cross out B, C, and D, and easily we can get to A. Although the way they word it is not the best, and it's a little bit confusing, but it still is the best answer out of the four. So 56 is A. 57, assume Barney refused to perform his promise to buy Samson's business and Samson sued. Barney defended on the ground that at the time the contract was signed, the parties orally agreed to that Barney's obligation to buy was conditioned upon Barney's obtaining a 5-year extension of Samson's lease, and that Barney has been unsuccessful in his efforts to obtain such an extension from the landlord. No mention of the lease was made in the contract. Sampson objected to the admission of evidence to prove such a condition on the ground of the parole evidence rule. Which of the following arguments that Barney might make has any chance of avoiding the parole evidence rule? So, if I can recall my memory, parole evidence is for oral or written evidence that was made prior or contemporaneous to the agreement. But if the contract is totally integrated, it means that no additional evidence can be admitted. But if it was partially integrated, that means evidence that doesn't contradict, right? If it contradicts, it can't be admitted. But if it doesn't contradict the written agreement, then it may be admitted, right? So here, Barney, you know, is the one. I mean, Samson is the one that is saying that this 5-year extension story can't be admitted because it violates the parole evidence rule, right? Because it's materially alters and it's not consistent, right? So it can't be admitted. That's what he's saying. So the best argument for this is that the contract was not totally integrated, meaning no other a clause in the contract saying that no other evidence can be admitted. Whereas if it was partially integrated, then additional evidence that was made prior or contemporaneous with the contract may be admitted. So here we have C, which is talking about exactly that, whether this contract was partially integrated or a total integration. And the best argument that Barney can make in this case would be that the contract was partially integrated. Another way to say that is that the writing was not an integrated written contract. So C is the right answer here. Well, A says the evidence is offered to clear up an ambiguity in the writing. I've seen this question before, and they throw this on for A every single time. And the trick here is that there is no ambiguity here, right? I mean, they're talking about whether or not this 5 year extension clause should be included or excluded. That's not an issue of ambiguity in which there could be two or multiple meanings behind a clause or a word mentioned inside of the agreement. So, A is an answer that is wrong, but it oftentimes come up as choice A. And I've seen this trick before on other questions. So make sure when you see a parallel evidence rule, make sure to know that whether or not they're testing you on ambiguity, in this case they're not testing you on ambiguity. So that is not the right answer. And before realizing this, I chose that because it sounds good, but make sure to know that this question has no ambiguity. So A is not the right answer. Evidence is offered to show a modification of a written contract. Modification is something that happens after a contract has already formed. We're talking about prior or contemporaneous evidence that was made when the agreement was signed, right, between the parties. So here we're not dealing with modification, So B is wrong. D says parole evidence does not bar evidence of the oral agreement because the evidence is offered to establish an oral condition of a promise contained in an integrated written contract. That just, is that goes against the parole evidence rule in which I just, try to recite in my memory to you guys. So 57 here, C is the right answer. All right, so let's look at 58. So Al lived in a home adjacent to a large stretch of open fields. One afternoon, Al took his dog on leash for a walk across the fields. Unknown to Al, Bert was engaging in target practice with a revolver that Bert owned. Bert was hidden from Al's view by a small clump of trees. As Al, with his dog, passed the clump of trees, Bert fired at a target that he had pinned up to one of the trees. The sound of the explosion frightened Al's dog, which broke the leash and ran. The dog then bit Charles, who was walking in the fields about 100 feet from Al. If Charles asserts a claim for damages against Al, will Charles prevail? Well, obviously, this is not going to be an intentional tort question. This is not about a inherently dangerous dog with propensity to be dangerous. So this is not that type of question either. Obviously, this is going to be a negligence question. So here, you know, when you look at the answer choices, D kind of mentions the word negligence because it says no unless L was negligent in not restraining the dog. And that is the right answer because, as you know, negligence requires duty towards foreseeable plaintiff, pause graph. Now, the person has, the defendant has to have breached their duty of care, right? So that's what they're talking about here. He wouldn't be liable for negligence unless he was negligent in restraining his dog, right? Because he didn't breach, you know, because it was a gunshot that was heard and dog kind of just jumped up and got scared and got off the leash and bit somebody, right? So unless he was the one that breached his duty to take care of his dog, he wouldn't be liable for negligence. So if you go through the first two elements of negligence, yeah, he had a duty, but did he really breach that duty? He may have breached that duty if he was the one that was not, responsible for restraining that dog, but if he wasn't the one that breached the duty to take care of his dog, then he would not be liable for negligence. So 58, we know that D is the answer. And C, it says no unless the dog had previously bitten some other person. And that was what I was talking about. It's more of a strict liability, inherently dangerous animals. But, this question again is not, the fact pattern is not telling you anything about that dog being inherently dangerous. This is a fact pattern in which uh, they're testing you on your knowledge of negligence. So 58D would be the right answer. If Charles asserts a claim against Bert for damages for the dog bite, will Charles prevail? Right? Well, if Charles asserts a claim against Bert, the thing is, again, I think I mentioned in the previous question that there are two theories when it comes to establishing duty, right? The first theory is, you know, plaintiff or defendant owes everybody a duty, right? Whereas a defendant owes a duty to foreseeable plaintiff, right? So in this question, they're saying that was an injury to Charles from a dog bite. Was he was the plaintiff a foreseeable plaintiff, right? And in this question, they're saying that unless he was a foreseeable plaintiff, or unless he was in the zone of danger, he wouldn't be liable. So 59, we know that C is the right answer. No, because injury to Charles from a dog bite was not a foreseeable consequence of Bert's act. And I guess we can also interpret this question using the causation element, using whether it was a proximate cause or whether it was foreseeable cause. And the best argument that Bart can say is that the injury was not a foreseeable injury. When a dog jumped, because of a gunshot, got loose, that wouldn't be something that would be foreseeable under the reasonable circumstances. So 59 here would be C for the right answer. Joe and Tom saw a new automobile owned by Bill parked on a street. They decided to take the automobile for a joyride. Joe drove the automobile a few blocks before colliding with a truck. The collision totally destroyed Bill's automobile. If Bill obtains a judgment against Joe based on conversion and Joe pays the judgment, may Joe compel Tom to reimburse him for any part of the amount paid to Bill. This was another question that I kind of struggled with, to be honest with you, because I guess for conversion, um, when you have two tortfeasors, and when one of the tortfeasor is basically the main tortfeasor and the other person is not, I guess the main tortfeasor can't really ask for, I guess you can say, indemnify or give back the money owed to the plaintiff on behalf of, I guess, the plaintiff. So here, I guess if it was like not a conversion case, if this was like an intentional tort, maybe in negligence, then the story may be different. But because this is a conversion case, when there are two tortfeasors and one of them was the main culprit, or in other words, main tortfeasor, and the other one did not really participate in conversion, then I guess when you are trying to, when one main tortfeasor, is trying to get judgment from the other tortfeasor to lessen his own judgment, I guess when it comes to conversion, it's not possible. This is another kind of what the heck kind of rule that you'll only learn when you do many of these MBE questions, because again, I mean, this is not something that you're going to learn in law school. Maybe you did, but I didn't, because these are like detailed nuances of conversion, whether one tortfeasor can ask for a contribution or indemnification. That's the word that I was looking for, contribution or indemnification. And in this case, for conversion, I guess it's not possible. So D says no because Bill's judgment was based on conversion. That is the right answer. So let's look at 61. So 61 and 64. I'm not sure if it's all four questions or just three, but they made a mistake. And what mistake that is when you come to like 63, they use they start out with Tom and Jim, right? But when you go down to 62, um, Tom disappears, and they replace the name Tom with Coin. You see here, Coins sues Tom. And I guess what happened was that they miswrote the test, because when you look at the call of the question, um, it's Tom and Jim who had a relationship, not a relationship, but a contractual relationship, and the rest of the questions are based on that contractual relationship. But all of a sudden, they make a mistake of calling Tom or Jim Coin, and they do that for 62 and 63, and then for 64, they ask you a question uh, in which you had to assume something in order for the answer to make sense. So they made a mistake for these four questions. And when you look at the answer sheet, 61, 62, 63, 64, answers are A, B, C, D on all of them. So that should show you that they made a mistake for these questions. But nonetheless, if you want to take a look at them, they're a great review. Like number 61 is asking you whether or not you are aware of what constitutes as an offer when it comes to advertisements. And the rule is that for advertisements to constitute as offers, it needs to be definite. It needs to have identifiable party who can participate in it, and such as, you know, this ad is offered on a certain date to a certain date to any customers who walks into the store at a certain time. That is a definite offer because it identifies who can accept the offer, also stating the price, obviously, quantity. And if you have these definite terms, then an advertisement can constitute as a valid offer. But without those terms, these advertisements would not be a valid offer. In 61, the offer in which Jim advertised in a news local newspaper is a special sale, coins on sale at 10% over their face value, right? But it doesn't state who can accept. It just basically has, special sale, coins at 10% over, that's it. And usually that's not definite enough to constitute as a valid offer. So when the question asks, a person who saw this ad, came and tried to accept this offer, and was denied, was did he have a cause of action? And 61, basically the answer is no, because special sale, coins on sale at 10% over their face value is not a definite offer, right? So for 61, Jim, who is the defendant, who put out the ad, ends up winning because the ad he put out didn't have material terms, definite terms. So when he was sued, he would win because the ad that he put out was not a valid offer. And when you don't have valid offer, whoever is trying to accept it cannot accept it because there was no offer, right? So 61A is the right answer. And 62, 63, 64, I think we're going to just skip them because the names are going to just confuse you. But if you still want to try it, I think I suggest that you do because it'll help. 62 is asking about statute of frauds. When two parties got into a sale of goods contract that is over $500, it needs to be in writing. But in this case, there was no writing. But after their oral agreement, one party sent the other party a letter validating the merchant's confirmation, basically confirming their agreement. And usually, I believe this is 2201. I would have to look at UCC again, but when there is a merchant's confirmation memo that is signed, which is sent after their oral agreement, that would constitute as a valid agreement in writing, right? So a party cannot sue the other party or defend himself, saying that that contract had to be in writing, but it wasn't. That defense wouldn't work because there was a signed writing by a merchant's, I think it's called merchant's confirmatory memo. You can check double again on UCC 2201. I think it's definitely not 2207 because that's Battle of the Forms. So I know it's 2201, and I think merchant's confirmatory memo is like section A, I think, or something like that. But yeah, here there was a confirmatory memo, even though there was no writing between the parties. After there was an oral agreement, one party sent the other party a confirmatory memo, and that acts as a valid writing in which it would satisfy the requirements of statute of frauds, right? So for 62, if one person is trying to argue the defense of statute of fraud, saying, this agreement is not valid because it was not writing, that will fail because there was a merchant's confirmatory memo, and the answer with that for 62 would be A, because the letter signed by Tom or Jim, it does satisfy the writing requirement because it was a merchant's confirmatory memo, right? So 63. Well, they're asking about consideration in a bilateral promise to promise situation. A promise to sell something and promise to buy, that could be sufficient consideration. And when a party is saying that it was a promise to buy and sell, not an actual exchange of value or bargain for exchange, because there was no actual exchange, but just promise, that shows that there was insufficient consideration. But that defense would not work, and in a bilateral promise to promise situation, when a party decides to promise the other party that they're going to sell the other party something, and the other party promises that they're gonna accept that offer to sell, then that would be a bilateral, not a unilateral, bilateral promise to promise contract, and that would be sufficient consideration. So that's what 63 is about. And 64 is asking about illegality. When there's illegality, and there was a contract that was already signed by both parties, and then, let's say for some reason a statute made their future transaction, which was about to happen, made it illegal, then that's cause for a rescission in which each party will basically get to keep. If it's seller, the seller, doesn't can't sell it because it's illegal. So he may have to keep what he was about to sell, and the other party, if he paid for what he was about to buy, then he should get that money back. Or if he hasn't paid, then he can just keep that for himself, because transacting, it's like a common sense question. You know, if something became illegal, and if they go ahead, even though it's illegal, that would make the contract voidable, right? Void. So in this case, the each party would have to, hold on to their bargain of exchange or consideration, meaning one party, the seller, will have to keep what he was about to sell. The buyer, if he was paying with cash, then he would have to keep that cash to himself. Or if he has already paid the other party that cash, then he would, you know, under the restitution, or he would get that money back. And that's what question 64 was about. All right, so we're done for today, and I hope it was helpful. It seems like it's about 25 minutes shorter than other videos, but that's good because we're picking up speed. And as soon as we're done with these 100 questions, I'm going to go over every single community property essay questions that has been tested on the bar exam. I'm not going to go over hybrid questions like community property slash wills and trusts. I'm going to skip those, but if you look at just community property questions, I believe there are like 9 or 10. So I'm going to make a video for each essay, so that if anybody needs help with community property, then they could watch these videos. And since it's not MBE subject, just basically follow my way of writing it, because I got a 90 out of 100 on the midterm, and I feel very confident about community property. So I'm sure I have much to teach you, or much to share, so that you can get more value from these videos. All right. Again, thanks for watching, and I'll see you on the next video.